The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Good morning, councils, and for those listening on our Supreme Court YouTube channel while we're live streaming this oral arguments, welcome to our virtual courtroom. And will the clerk please call the case?
This is Supreme Court case number CRA19-006, People of Guam, Plaintiff Appellee versus Philip Vincent Caso, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Peter C. Paris. Appearing for the Plaintiff Appellee is Attorney Sean Brown. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Paris reserves 5 minutes.
Thank you. Mr. Paris, you may proceed.
Thank you. Good morning, Chief Justice Carbolito, Justice Torres, and Justice Merriman. May it please the court. Philip Caso was convicted in a trial tainted with multiple errors. Specifically, the trial court committed plain error when it admitted Exhibit 13 at trial. In order to convict Mr. Caso of distribution and possession of a Schedule II controlled substance, the government was required to prove as an essential element the existence of a Schedule II controlled substance. Exhibit 13 was the people's purported drug exhibit. In order to admit Exhibit 13, the people were required to present a witness who had personal knowledge regarding the exhibit and who would be able to satisfy the evidentiary foundations required by Rule 901. In the instant case, the people presented Officer Champion. Officer Champion testified, "This was the dope that was seized off of Cheryl. Aside from the field test, this is consistent with what I know methamphetamine to look like." On the basis of this testimony, the people moved to admit Exhibit 13. The defense did not object, and the court admitted Exhibit 13. Plain error occurred because the court did not satisfy the requirements of Rule 602 and 901. Specifically, with respect to Officer Champion, he did not seize Exhibit 13. He was not present during its seizure. He did not receive it. He was not in the chain of custody. He did not field test it. He did not lab test it. He had no Rule 602 personal knowledge, and he was unable to establish a Rule 901 authentication. It's plain error.
Mr. Paris, even, clearly, at least in my view, there are issues with Officer Champion's testimony and his lack of personal knowledge regarding Exhibit 13 and some of the circumstances concerning it, including its seizure from Brewer and authentication of the exhibit. But wasn't the exhibit also testified to by another officer who had the ability to lay the foundation for admission of Exhibit 13, specifically Officer Talahi? So if that's the case, what prejudice would Caso have suffered as a result of Officer Champion not having the personal knowledge and able to lay the foundation, but Officer Talahi did and was able to do so?
This was not a situation where the prosecution offered Exhibit 13 subject to the presentation of further evidence. The government moved to admit Exhibit 13 solely on the testimony of Officer Champion, but going further, addressing Your Honor's statements regarding Officer Talahi. If the court might recall, in looking at the record, Officer Talahi never connected Brewer to Exhibit 13. Officer Talahi did not know, she did not identify Brewer in court. She did not know who the source of information was. And she never was able to connect Brewer to Exhibit 13. She did testify that Exhibit 13.
Wasn't she the one who patted down Brewer and made sure she was clean before they went into the house and then also met with her at the predetermined location to recover the narcotics? That was Officer Telahi.
I believe Officer Terlahi, the record will show that she was never able to identify Brewer, either during a pat down, during the pre-controlled buy, or after. And in order to connect Brewer to Exhibit 13, she would have needed to identify her. She was not able to do so. And
No, but if I could just, but the issue right now, I think that Justice Torres raised has to do with authentication in terms of identity. That's connecting the drugs that Exhibit 13 represents is a little different. First, just in terms of laying the foundation and the authentication of Exhibit 13 being what it purports to be. The question was, couldn't Officer Terlahi provide that foundation to properly authenticate Exhibit 13?
And my response to that, Chief Justice, is no. And the reason I say no is because she could not testify that she obtained Exhibit 13 from Brewer. And she could not say she obtained it from Brewer because she could not identify Brewer as the source of the information. She never testified that Brewer was the person she patted down or the person who she received Exhibit 13 from. So whether it be through Champion, who had no personal knowledge, or whether it be through Brewer, who further had no personal knowledge, no authentication ever occurred under 901.
Well, I thought when you look at the jury transcripts of pages 82 and 83, that Officer Terlahi testified that Exhibit 13 was the bag of crystalline substance that Brewer handed to her after the controlled buy at the prearranged location. And so there was a connection between Exhibit 13 and who handed the meth that Exhibit 13 purports to represent from Brewer.
I respectfully disagree, Your Honor. That's not my recollection of the record. I do recall that there was testimony regarding how the controlled buy was set up. But in terms of connecting Brewer or Caso to it, Officer Terlahi, in my recollection, was not able to do that. She did not testify regarding Brewer specifically. And certainly Officer Champion could not establish the foundational requirements of 901. So I recall the testimony, but I specifically recall Brewer was never connected and Terlahi could not identify Brewer. And I think this is a threshold exhibit. If they don't have Exhibit 13, they've got zero case. And in deciding whether or not to admit Exhibit 13, a crucial exhibit, I think it was incumbent upon the people to satisfy the foundational requirements with people with 602 personal knowledge, and further with the trial court to make sure that these rules are being observed and satisfying. Because what I'm seeing again and again when I handle these appeals is a real casualness about these rules and enforcing them. And this results in conviction after conviction, and we're dealing with felony level charges. And I think it's very important that the government fulfill its burden of proof, whether it be satisfying the evidentiary requirements for admissibility or the elements of the offense. And I submit to this court, the record reflects that that did not happen in this case. And that constitutes plain error because the court admitted Exhibit 13. The error is clear and obvious because Rule 602, 901, and the hearsay rules were not satisfied. And the substantial due process rights to a fair trial and application of the evidentiary rules was not applied, resulting in a conviction, which is a miscarriage of justice. These rules are put in place to protect defendants and to ensure that trials are done fairly and these rules are not applied casually or perfunctorily. And what I'm seeing in this case specifically is that happening again and again and again, which would bring me to the second issue if the court doesn't have any other questions on issue 1, which is issue 2, the recording. Now, in the recording, we also have an issue where we have Officer Champion being the witness through which Exhibit 12 is being admitted. And we have Rule 602, he has to have personal knowledge. We have Rule 901, he has to establish the the foundational requirements. And we have the TUNCAP decision in which this court gave the court and all of us guidance about admission of recordings. Again, I will recognize that the court ruled that these are not to be applied inflexibly. These are, for guidance purposes, and courts can consider other factors in determining admissibility of recordings. But what we have here is Officer Champion, who did not have any personal knowledge regarding some of the factors the court gave us guidance about, regarding how the recording system operated, regarding its working condition and pattern of maintenance, who was operating it, had access to it, and maintained it, who archived the recordings, regarding the quality of the recordings and the means by which the recording was copied to the format received at trial. Again, these aren't mandatory, but they're for guidance. And what we heard from Officer Champion was, when he's asked questions about the recording, he says, I guess. We hear hesitancy in his responses. He identified some voices. He identified Brewer sometimes. He identified Caso sometimes, but there were multiple voices. And there were multiple instances where he could not identify the speaker. And there were multiple instances where the recording was indiscernible. And again, it's very important when we're having a felony trial that the rules and standards be observed and not be applied perfunctorily or in a casual manner. And in this instance, plain error occurred because the court admitted Exhibit 12 without objection. The error is clear and obvious because Rule 901 was not satisfied. The TUNCAP factors were neither 901 nor TUNCAP. Those factors, they were not discussed or applied. And as a result, these affect my client's substantial rights to a fair trial, due process, and application and enforcement of the Guam Rules of Evidence. And as a result,
Officer Champion was sitting in the car next to the home while the transaction was going down. He was monitoring the conversation. He testified that the audio recording was a fair and accurate representation of the audio that he heard during the buy. He acknowledged that the recording was of a low quality and that it was comparable to what was created at the time that was there. So, being present at the scene, although he couldn't observe the transaction and he didn't discuss specifically, the system in which it was, how the recording system would operate, et cetera. It seems that some of those factors that were identified in TUNCAP about the quality of the recording, the means of the court recording, the fact that, he was there listening to it live, does, I think, provide maybe an alternative means of authentication that was recognized in TUNCAP. What's the problem with his testimony specifically, and what, the fact that he was there that would potentially not meet these, the recognition in TUNCAP that there might be alternative means of authenticating video recordings, video audio recordings?
and I guess
he recognized their voices too, right? He said it was both Caso and Brewer.
And I guess that's the question, Your Honor, and that's maybe the guidance that this court gives us as we apply, as we deal with admissibility issues in future cases. Is that enough? And with respect to factors 1 through 5, I would submit that those were not met. And I recognize that this court has said you can look at other factors that are not delineated in TUNCAP. And I guess the question is that enough? Are those factors that Your Honor mentioned that are in the record sufficient? I know that if I were handling this case at the trial level, I would have vigorously been opposing the admission of Exhibit 12. And I would ask the court to require whoever made that recording to come in and authenticate it. Because if those factors are not enough, if those factors you mentioned are not enough, then the other factors are not there. And again, I would submit that these rules should be applied, carefully and not casually. And my impression from the way this trial went forward is that there was a very casual application of the rules. For example, Exhibit 12 was played before the jury before it was even admitted into evidence. I mean, that to me, that's very telling. You don't publish to the jury an exhibit or a piece of evidence until it's been admitted. This was played before the jury before admission. But again, it boils down to, yes, Your Honor, if those factors you mentioned are sufficient, then we can be guided by that in the future. I would submit that the other factors that are delineated were not met. And really the more proper course for the people's case would have been to have the person who did the recording come in and authenticate it. Which would bring me to the third issue, which is the qualification of Mr. Caton as an expert in controlled substance drug recognition. And I would submit plain error occurred here also. And there was also a casualness with which the court and the people addressed Rule 702's requirements and this court's Supreme Court precedent in cases like In Re NA and the Roten case and the federal case Dalbert. And I recognize that the record shows, okay, Caton gave his educational background. He talked about his experience as a criminalist. He talked about the 6 times he testified, 5 times in Palau, 1 time somewhere else. Okay, people make your motion, but in making your motion, talk about 702 and talk about how they're satisfying it. And when the court decides whether or not 702 has been satisfied, the court should determine whether or not the people have met their burden. The burden is on them to qualify Caton as an expert. So in applying 702, was his opinion based upon sufficient facts and data? Was it the product of reliable principles and methods? Did the witness apply the principles and methods reliably to the facts of the case? That's what 702 requires. That was not addressed. In Re NA, this court said that you have to look at whether the witness is qualified via knowledge, skill, experience, training, and education. And will the testimony assist the trier of fact before allowing that person to give testimony as an expert? And under Dalbert, the testimony must be both relevant and reliable. And in this case, those standards were not even discussed. The people did not say, we moved to admit him before in accordance with Rule 702 for these different reasons and how these factors have been met. The court did not assess that or analyze it. And again, it's a casualness of application or even disregard of the formal rules that apply to these issues. It's plain error because the court qualified Caton as an expert without application and reference or findings regarding 702.
Mr. Paris, but the defense counsel didn't object, and can't a defendant consent to a person being held as an expert without the strict application of 702?
I know they did not object. I don't remember if they consented. And let's say they did. If they consented, does that mean that this court cannot? I would say that even if the trial lawyer consented, that does not mean that on appeal, a defendant who's been aggrieved cannot say that this was plain error. And
well, I mean, I think clearly Caton had some specialized knowledge that would have been helpful to the jury. I mean, clearly, I think the better practice is for the trial judge to make some specific findings when ruling on his qualifications as an expert. But even in the absence of that, he was not there as a lay witness. He had, performed, I think he testified something like 5,000 different examinations using the FTIR process. And, you mentioned his prior experience as well. So it appeared that he had some specialized knowledge that was going to be helpful. And without the objection, I have a hard time understanding why he would not qualify to be an expert on controlled substance recognition?
Well, first of all, my recollection of the record is it was 5,000 times testing using the gas chromatograph. That was my recollection, and I prepare to stand corrected. But they could not offer him as a lay witness because they have to pick. Is he going to be offered as a lay witness or as an expert witness? They opted to offer him as an expert witness. Yes, he had an educational background. Yes, he had some experience. Did it rise to the level of 702 expertise? That was never addressed. And if that is the standard, then we'll be guided by that. But I don't believe that should be the standard. And I think that courts should be, they're the gatekeepers regarding evidence. So if the government is going to offer somebody as an expert, the court should require them to meet their burden and should articulate how they've met their burden and apply the factors. And when that doesn't happen, we don't have a record showing that 702 has been met. But again, I mean,
we've stated that, you know, the better practice is for the trial judge to make a record as to those findings, as you have indicated, to articulate the requirements of 702, and based on the record, how this was satisfied. And you are correct. In this case, that was not done. But despite that apparent shortcoming on the part of the trial judge, can our court make those determinations based on the record, even without the trial judge's articulation of how Rule 702 was satisfied? And part of that, I guess, goes to Justice Merriman's question, is that if the parties were to consent that this individual qualifies as an expert, is there error in reference to the record not being articulated that the requirements of 702 are met?
I think on appeal, it would probably be more of a waiver argument that you can't raise this on appeal because your attorney consented. Then it would become a writ of habeas corpus issue for ineffective assistance of counsel. With respect to the issue of do you make a determination on appeal? I'm not asking this court to make a 702 determination. What I would ask the court to consider is vacating the conviction and remanding it. Require the requisite finding to be made at the trial court level. And this brings us to the next issue regarding Caton's opinion regarding it being methamphetamine. So first, if he's not an expert, he can't give the opinion. But then he attempts to give the opinion. In order to give the opinion, he needs to establish that there's a foundational basis, that the testing methods were reliable. And in order to do so, he needs to establish that the devices used, the instruments, were properly calibrated, maintained, and operating. And in this case, he could not establish that the FTIR, which was one of the instruments used, was properly calibrated. And he agreed in his testimony that the FTIR required proper calibration. He didn't have any knowledge when it was last calibrated. He said it would require an off-island expert to come and calibrate it. He didn't know who that expert was, where that expert would come from. When the FTIR was last calibrated, he knew it was not calibrated since he was a criminalist working for the people, and he did not know when calibration would be required, and he would need to speak to his supervisor. To me, these are infirmities that establish plain error regarding his opinion. He could not establish that the instrumentation was properly calibrated, therefore he could not testify that Exhibit 13, which should not have been admitted in the first place, was methamphetamine. So
was there some testimony for him that if it wasn't working, he would not use it? So, which could insinuate that since it was working, it must have been calibrated?
We've got, I remember that testimony, and what we have is inconsistency regarding the different things he said. So again, it comes to the court being careful about whether or not to allow this testimony, whether or not to allow the opinion to come in. Was it sufficiently based? And that analysis was not made.
Let's
Granted,
say
there was no.
we agree with you and said that the equipment that they didn't lay the foundation of calibration and maintenance of the machine, and therefore could not use that test to establish that Exhibit 13 was methamphetamine. But wasn't there also another test, the color test, that was done on the methamphetamine? And didn't he also testify about that, the presumptive positive as a result of that test? Why wouldn't that be sufficient to establish that Exhibit 13 was methamphetamine?
For a number of reasons. One, because it's presumptive, not conclusive. Secondly, in order to establish conclusivity, it requires the criminalist to go through a series of tests, including the stereoscopic exam, the color test, the FTIR, and the gas chromatography. It's not just one. They may be indicative of a presumption of positivity, but in order to meet reasonable doubt at trial, it must be conclusive. And that's why the government cannot go forward on cases based upon presumptive tests. They must bring the criminalist in, who is an expert, to establish a conclusive test. And those are the
Does
reasons.
that go to the weight of the evidence or to the admissibility, in terms of the fact that he couldn't do the confirmatory test does not invalidate the presumptive test or inhibit its admissibility, but it just goes to the weight of the expert's testimony?
I think it would. I think if they did not have the lab, first of all, I don't disagree that a presumptive lab test is admissible as evidence if it's properly brought in. But putting that aside, if that's all they have, it would be ripe for a motion for acquittal. They must present a conclusive lab test. I don't think it's a weight issue. It's a burden of proof issue. And presumptive is basically that, presumptive. It is subject to confirmation. And without that, it would be subject to a motion for acquittal if there was a conviction.
Mr. Paris, is expert testimony required, or is Brewer's testimony sufficient?
An expert testimony is required. Brewer does not have the ability to testify to what an exhibit is. She can say she believes it's methamphetamine. She can say she's transacted trafficked methamphetamine before, and she knows what it looks like. But in order for Exhibit 13 to be identified as methamphetamine, you need an expert. She doesn't have the competence or the ability to testify. Other than those issues.
I'm sorry, go ahead, Mr. Paris. I just note that your time is up in terms of how much you reserved. Less than 3 minutes remain, just for your information.
Then I'll just make the quick comment regarding plain error, regarding extensive hearsay, and ask the court to consider that argument. I also mentioned the government's brief did not comply with Rule 15 and 13. I didn't make a motion to strike I didn't make a motion to strike, but just for informational purposes, it makes it hard to defend an appeal when 13 and 15 are not complied with. I'll reserve the rest of my time if that's possible.
All right, thank you, Mr. Paris. Mr. Brown, you are recognized.
Chief Justice, may it please the court. So regarding the 6 issues that were raised in the written briefs and by Mr. Paris's oral argument today, Mr. Officer Champion was a competent witness who testified factually to the foundation and the basis for his testimony regarding the drugs and regarding the recording. Mr. Caton was deemed an expert properly, and he did testify to his training and expertise in the field of drug testing, and that he correctly used the machine to obtain a conclusion.
Mr. Brown, how was Officer Champion, what personal knowledge did he have that Exhibit 13 was the methamphetamine seized from Cheryl Brewer. He wasn't present when, you know, that item was turned over. He wasn't present after the controlled buy, you know, at all. He also wasn't the one that conducted the field test on the exhibit. So he didn't seem to have personal knowledge about the field tests that was conducted on Exhibit 13. And so, you know, I don't see how you can assert that he had the personal knowledge that Exhibit 13 was the evidence that was seized from Brewer following the controlled buy.
So first, he was the supervisor for the Mandania Task Force, according to his own testimony. So he's kind of like the operation boss for this entire sting. And he testified to how the protocol operates. They do the sanitation, they do the audio recording device to make sure it works. Then they bring the source to the sting site. He testified to the whole process in the way this works. And he also listened to the conversation between Caso and Brewer.
And there's no dispute about that, but it's the personal knowledge of the evidence that they took from Brewer following the controlled buy. And it's also the conducting of the test on the methamphetamine or the suspected methamphetamine after the confiscation. And he testified he wasn't there when both of those things happened. So when Exhibit 13 was admitted, there was no foundation, it seems to me, or authentication to admit it into evidence at that time.
Your Honor, if I may, on page 16 of the transcripts, Mr. Phelps presents Officer Champion Exhibit 13, and Officer Champion testifies that it looks to be a vial of white crystalline substance, about a gram. The question then is asked, and is this vial of crystalline substance familiar to you? Officer Champion says, yes, it is familiar to me. He didn't say that part, but he says yes. The next question, how is it familiar to you, or how do you recognize it? How would you ever know what this is? This is the dope that was seized off of Cheryl. He specifically identifies Cheryl. Okay, is that the same dope that you observed on September 25th, 2018? It appears so, sir. By that line of questioning and those answers make it very clear that these are the same items. Exhibit 13 is the same drugs Officer Champion observed on September 25th, 2018. The only way he could answer those questions that way is if he actually observed them. The way the question was asked and the way it was answered, yes, this is what the dope I observed.
Mr. Brown, there was testimony that after Ms. Brewer came to the agreed site, after she left the location where Mr. Casal was and his home was, his testimony was that he then left and went back to the police station. He didn't go to the subsequent site where Ms. Brewer agreed to meet the officer so that then she can properly turn over the meth that she received from Mr. Casal at his residence. And so how is it that he can have personal knowledge when he was not there when it was turned over?
So we don't know at what state.
I mean, the statements that you're reading is that it can also be understood that he was told that this was the case, but that's quite different from personal knowledge.
So, Your Honor, Mr. Officer Champion was present with Officer Terlahi during the sanitation of the vehicle for Mrs. Brewer. So when they went
before the purchase.
So if the car and Miss Brewer are clean before the sting begins, and Officer Champion has personal knowledge because he helped sanitate, he helped do the sanitation. If there are any narcotics that return, they could only have come from Mr. Caso or from Mr. Caso. There's nowhere else that the police took Miss Brewer, and they cleaned her car. So when she came back, the only person that could have given her that is Caso. That doesn't require any verbal statements whatsoever. When she comes back with an item, the only person that could have come from is Mr. Caso.
But he doesn't even know that she came back with an item because he wasn't there when the item was turned over. They went to a different location. So he has no knowledge of what came back. He didn't know what it looked like, and he didn't test it. And yet he testified to all of that.
He also testified that aside from the field test, so he may have not done the field test himself, but he is Officer Terlahi's supervisor, right? He said that he is the boss for basically Mandania Task Force. So he's the one that's operating these things. He may not have done the field test himself, but he did say, aside from the field test, this also looks like what I know methamphetamines to look like. So he did his own separate independent inspection with his own eyes of the item and said it looks like what he thinks ice looks like. So he didn't just rely on whatever verbal statements were made. He relied on his sanitation of the car prior, his listening while live, the audio recording of the transaction between Miss Brewer, who he has history with. He knows what she does on a daily basis because of their prior history together. They work together. She has done prior stings with him before. She testified later that she gets routinely ice from Mr. Caso. Mr. Officer Champion knows these things. If you combine it all, there is a basis that he would have, in addition to his own visual inspection of the narcotic. We don't know when, at some point prior to the trial. So if you combine all that information together, there is a substantial piece of evidence that forms the basis. But he testifies, this is the same dope I saw on September 25th. He must have laid eyes on it if that's his testimony. If there's going to be an argument that he has lied or that he can be impeached, that is something different. This is regarding authenticity and admissibility.
What if he saw the dope at the police station after, and he doesn't know how it came into the possession of the police? He wasn't there when it was turned over to Officer Terlahi. He's only hearing from Officer Terlahi potentially. I just think there's big gaps in the authentication and the knowledge for admitting this exhibit into evidence with the foundation that was established at trial. At least through Officer Champion, there might be another way that the exhibit could be brought in. But when you have him, yes, he was at the controlled buy, there's no doubt, but he did not go to the drop-off point, the previously arranged drop-off point. So he didn't know what she had. She could have come out with nothing. She could have come out with something else besides methamphetamine. He may have been out of methamphetamine, came out with cannabis or marijuana. Who knows? I mean, we just don't know what happened. And for him to testify that he wasn't in the chain of custody of the items, he's not indicated as being in the chain of custody. So I just have a difficult time accepting his testimony as the foundation and authentication for admissibility of that exhibit.
Your Honor, I understand, but he heard the transaction between Brewer and Caso as it was happening via audio recording device. So he heard the conversation that they had before they left the sting site. So he would have heard Caso providing her with something, right? He would have heard that happening. Why does he need to see it for himself when he was present as it was occurring?
She could have provided him pills and not methamphetamine. He could have provided her something else. I mean, who knows? That's the difficult thing I have is he never saw the item. He wasn't there when it was seized from Cheryl. He wasn't there at the predetermined location for the drop-off. He wasn't the seizing officer. He was not in the chain of custody. So, I just have a tough time.
Understood, Your Honor. He did testify that he saw the drugs. So if we're going to attack that and say that it's not authentic, that he said he observed it himself on September 25th, the day of the operation, there was no testimony of any other operation that day. There was no testimony of any other item confiscated on September 25th, 2018. The only item that was confiscated that there was testimony to this date was Exhibit 13, which he said, I observed myself on that date. I believe that would be a sufficient factual basis. I understand if that's not, but that would not, if we're going to be attacking Officer Champion's credibility versus believing him when he says he laid eyes on it, I understand. But again, this testimony, at least by Mr. Morrison's standpoint, the trial defense attorney, he would have seen what was going to come down the pipeline. from Officer Terlahi, Officer Egros, Mr. Caton, and Ms. Brewer. And why are we going to fight this now in front of the jury? It was a strategy. It was a decision to make at that point that we're not going to be fighting this. So that way he looks like he's uncomfortable with the witness instead of making the jury think that he's afraid of this evidence. It was going to come in eventually. So moving on to issue number 2, the audio recording. Again, Mr. Perez argues that there's no competency for Officer Champion to testify to this. The people's point of view on this, Your Honor, is that Officer Champion was present live during the conversation. There was testimony by Officer Terlahi as well later, of course, that the device was working. Officer Champion says that usually before they do the sting operation, they do confirm that the audio device is working. Officer Champion testified that he listened to the recording prior to trial, and this was the same conversation that he heard live on September 25th, 2018. So the foundation, we believe, for Officer Champion to testify regarding the audio recording was made. Yes, there was not an express discussion of the factors under TUNCAP, but the court did not have to go into the specific factors, 1, because there was no objection, and 2, because there was an otherwise factual basis laid that we know the jury and the trial court knew that the audio recording was what it purports to be, a conversation between Caso and Brewer on September 25th, 2018. Regarding the qualifications of Mr. Caton as an expert, the people's position is that there was substantial testimony, not a barren of factual discussion, but a substantial amount of testimony as to the qualifications. As already discussed previously between the justices and Mr. Perez, there was testimony that Mr. Caton was a criminalist for 3 years and 2 months. He had worked on 181 cases during that time frame, 5,000 tests. He has a background in science. They actually discussed the specific science classes that he took. He obtained in-service training for the FDIR and the gas chromatograph instruments. He's well trained in the other types of testing that are conducted by Crime Lab. He testified to all these things, and he even testified that aside from obtaining evidence from Officer Terlahi, the Crime Lab does their own independent inspection of these items. So there was a substantial amount of information that went into the qualification for Mr. Caton. And factually, there's no information that's lacking, I believe, based on him testifying previously as an expert in 5 cases here on Guam and 1 in Palau. He also testified that he looked at the item himself, a visual inspection, I believe under a microscope or some sort of a scope to make sure it's visually consistent. He did his own color test with the narcotics, it's a field test similar to the one done by Officer Terlahi. And then he did the FTIR instrument test, the scientific testing. So regarding his qualification,
Mr. Brown, Mr. Perez's arguments is, while all these evidence came into the record, is the trial court never made any findings as required under 702, the elements, to qualify Mr. Caton as an expert witness. I think we have articulated in prior case law that it would really help upon review for these findings to be made. I mean, is there anything in the record that from this evidence, the court made a finding that Mr. Caton qualified under 702 to be an expert witness?
So there was not a specific finding, I believe, that the court made. A lot of that's because there was not an objection at trial, so there's not a need to go into the deep arguments. The people's point of view on this is that, imagine if a court does say, well, under the 702 factors, and then it goes through those, what's the jury going to think about that? Isn't that kind of confusing? They're not going to get a jury instruction on 702 later. So for the judge to do that, maybe if we did a sidebar approach to it and had an argument on that, maybe that'd be, but otherwise we're going to just end up confusing the jury even more, especially if there's kind of an agreement on Mr. Caton's qualifications here. We're not fighting that. Why are we going to then try to confuse the jury by going over the legal factors? And finally, again, the key word in factors is fact, and we're looking at facts here. What are the facts for the basis for Mr. Caton?
Yeah, but
the facts are
the trial judge under Albert is the gatekeeper, and under 702, I mean, the trial judge is the one that makes that determination whether or not the witness proposed to be qualified as an expert it satisfies the requirements. I don't think that that would be a best practice, that we just allow whatever testimony and that there is no determination on the record. What's the use of Rule 702 if just anyone can come in and articulate some credentials and say, I'm an expert?
Again, the trial court has been given discretion on the factual circumstances to give analysis to. In the Rowan decision, it looks like the trial court's in the best position to make that determination because they're there with the testimony live. And again, here we don't have that objection to lead into the legal argument as to what exactly the factors are. However, yes, we did. The trial courts definitely need to apply the rules and make sure that we're not just willy-nilly letting evidence in, even when there's not an objection. But here, even Rule 705 talks about how the expert does not need to go into the underlying facts or data unless the trial court requires. So if the court doesn't see an issue here, if maybe, Judge Sokola was, I believe, the drug court for some period of time. So, and I'm not saying that she needs to rely on her prior knowledge of this. However, she looks at Mr. Caton and sees that the testimony makes sense with what he's saying. Is he an expert? Yes, he did the things experts do. He has educational background. He testified to these things. The court doesn't require to go further into that because the trial court, who was present during the testimony, saw him as an expert. And Mr. Morrison did not fight that. One, maybe for strategy, and two, because he also knows that Mr. Caton carried out his job duties correctly and did a proper scientific test on Exhibit 13. Moving on to the machines. Mr. Perez's main argument here is that there's not proper calibration for the FTIR machine, FTIR instrument. So I'm going to bring the court's attention to, I think this is page 98 of day one trial transcripts. And the question is, okay, how do you conduct the FTIR test in this case? Prior to running the FTIR, the Fourier transform infrared spectrometer, a ValPro qualification was ran to ensure that the instrument was working with the parameters for analysis. So there was a test conducted on the machine to make sure it's operating correctly. And what's the ValPro qualification, Mr. Phelps asked? Mr. Caton, it is a parameter scan of the instrument to assure that it's working within standard operating. Okay, so essentially the instrument scans itself and tells you it's functioning correctly. The answer is correct. So before Mr. Caton conducted that test, he made sure that the machine was operating correctly within parameters. And it's not just, okay, is the machine turned on? Okay, fire it away. No, he made sure that it's operating according to the ValPro standards. In addition to his own visual inspection with the microscope, in addition to the field test, Mr. Caton did 3 independent tests on this item to make sure it is what the people believe it is, which is methamphetamines. And that's in addition to
there's some precedent from some jurisdictions that although that when looking at laying a foundation for admissibility of FTIR, that you have to show it's reliable and that at least have testimony when the machine was confiscated, calibrated, and it has, and so at least in these jurisdictions, the foundation establishing the proper calibration of the machine is a critical factor towards ensuring that the appropriate foundation is laid for admissibility of a FTIR test. We haven't established that rule, of course, yet. But why is that something that we shouldn't consider, that requiring the foundation of proper calibration and maintenance of this equipment, following the case law of these other jurisdictions? And Hawaii is one of them, before the expert testimony relating to FTIR analysis can be admitted?
First, there needs to be an indication that the machine's not working if we're going to be requiring calibration. The testimony in this case is that the machine was operating perfectly within standards. And that if it did require calibration, we'd have to fly somebody. Remember, Guam is a small island. We don't have infinite resources. We'd have to fly somebody in to calibrate the machine. So the second it goes down, there's not going to be any testing conducted, right? We'll put a stay on testing, get someone to fly out. But that would require the machine to be malfunctioning. Here, there's no testimony to that. So if we're going to require that standard, it could negatively impact the way we do drug testing. We might lose a machine because it's not routinely calibrated. The testimony was it doesn't need to be calibrated until the assumption is until it malfunctions, and then we got to fly somebody in to fix it because we don't have somebody here on Guam to calibrate the FTIR. So I mean, we can use that, but we can also look at the case law on the intoximeter device. That's also a self-calibrating machine. So in that case, if the machine says, okay, I'm working correctly, let's do the test, that should be a sufficient basis. And we have that testimony in this case, that we're following the protocols in place. We make sure the machine's working. But again, we have that in addition to the visual inspection of the exhibit, the separate presumptive test of the exhibit, in addition to Officer Chalahi. So now we have 4 tests all confirming the same thing. So Mr. Caton not only relied on the Valpro procedures to make sure the machine's operating correctly, but he's also relying on other tests to confirm that. We're not just willy-nilly prosecuting people and arresting people for narcotics unless there's a guarantee the item is methamphetamines. So there are guarantees here that show that the police did a pretty thorough job. Not just the law enforcement officers, but also the criminalists did a very thorough job making sure the ice or the methamphetamines were exactly what we thought they would be. Regarding the hearsay issues, there's actually two separate times Brewer identifies Mr. Caso as her source. One, when she's first arrested by Officer Champion and Officer Egros, she says, or they find the drugs on her, and she says, where did you get these? And she said, from Mr. Caso. That hearsay statement is out of court for sure, but it's also not relevant to the methamphetamines used at trial. So it's not offered for the truth of the matter asserted. It's more for effect upon the listener. Here, Officer Champion pulled her over, heard this information, and said, now we're able to conduct an operation where we will do a controlled buy. So it's more like the Kamadou case where the information given to Officer Champion about who the source is wasn't just for that relevant information. This is ICE from Mr. Caso, but that we're going to be able to do a sting now for Mr. Caso. So I believe that that's not a hearsay statement, the original. Regarding the statement she made on September 25th to Officer Champion and Officer Chalahi and what was said at trial, that would be a separate statement, an independent argument. So for that one, it's again her identifying somebody immediately after perceiving that person, and that's 801D-C, purposes of identification. So she, and also again, Officer Chalahi sanitized the vehicle, and then they go and get the item, and they come back. The only person that could have given her Exhibit 13, Brewer that is, would have been Mr. Caso. So there does not need to be any here statements that get us to that information. The only person that could have been the source of the narcotics Exhibit 13 that were admitted at trial would have been Mr. Caso. So that's not relying on out-of-court statements. It's also for purposes of identification. So those 2 statements are not hearsay; they're not excluded. Regarding the substantial information that this item Exhibit 13 is narcotics, Officer Champion's testimony, Officer Chalahi's testimony, Mr. Caton's testimony, and Ms. Brewer's testimony, they all testify that the item is ICE, essentially. Regarding that, there's independent sources of information for this. Officer Champion's testimony was not just based on what he was told, but based on what he observed himself on September 25th, 2018. Officer Chalahi's testimony was that she did her own field test on the item, and that was done with her own information, her own science, her own color test, and that was not based on solely information from somebody else. Mr. Caton's testimony, again, relied on 3 separate tests that he conducted himself and not relying on the information from other people out of court. And again, Brewer, when she testified as to what happened that day, she's testifying to the physical, actual events and not to what was said. And even if she did testify to what Caso told her, that's a party opponent admission in this case. So it's also not hearsay. So regarding all of the claims of hearsay and how they're improper, the people's argument is that each separate statement was its own exception or non-hearsay. And even if there was an error here, which the people believe does not exist, that information was corroborated by somebody else independently, and there would be no, there's no lapse there. So Brewer's testimony alone could have been sufficient. Regarding the argument of error, there is no prejudice for Mr. Caso regarding these errors, if there are any. People believe there's no error, but if there's no prejudice here, simply because even if Officer Champion's testimony was all struck, right? Even if it was all struck, Brewer's testimony in combination with Mr. Caton's testimony, Officer Chalai's testimony would have survived. And that would have been sufficient for there to be a conviction in this case beyond a reasonable doubt. I believe under the Mateo case, there's a discussion on there's a bootstrap section where even if the jury considers improper testimony, that information may still be considered by the jury for purposes of sufficiency of the evidence. And Mr. Perez has not argued sufficiency of the evidence, but there's been allusions to it during his argument and in the briefs. So even if it was relying on just Brewer's testimony, a flawed witness, that's not the case here. The jury got to consider additional information that even if under the Mateo case, even if it was struck, was properly allowed to consider those things. And again, in the Comadou case, there's ample error, very similar to hearsay issues. And that conviction was affirmed as well because the case was otherwise quite strong, which I believe is similar to our case today. So
in the last 3 minutes, Mr. Brown, you didn't get a chance to address, because obviously he raised it in his reply, that your supplemental excerpts of record didn't comply with our rules, and your opposition also didn't comply with our rules, specifically Rule 15 and Rule 13. The excerpts of record, you just included portions of the entire of the transcripts which you didn't use or cite in your arguments, and you just basically included the entire trial transcripts as opposed to portions of the transcripts in accordance with our Rule 15. And also that your brief was non-conforming because you didn't have appropriate cites to the record when you set forth your arguments. So I want to give you a chance to be able to address that before the court.
Regarding the failure to cite to the record in my argument, in the factual summary, I cited to the location of every fact in the excerpts of records and the supplemental excerpts of records. I neglected to do so in the argument. I had assumed that because I'm citing to the same facts previously and where they're located, I would not need to do so. That was an error on my part, but they are cited to. There's every fact that I assert is cited to the location in the excerpts of records, just in the factual portion. So when I restate the same fact, I do not apply the citation to it. I remind the court. I tell the court this is my first actual written opposition in the appellate court. So I did look at the rules. I thought I was complying with the rules based on my reading of it, and that I did actually cite to the record for those facts, just in a different portion of my brief.
And regarding to your credit, you did cite them in the statement of facts. So that is accurate.
And then regarding the using the entire record, Your Honor. So when I read through Mr. Perez's briefs the first time, I was quite alarmed at the allegation that the facts are barren and there's no factual basis here. But when I read the actual transcripts, we have these statements from Officer Champion where he testified to observing the dope. We have a lot of facts regarding Mr. Caton's background. So when he made these allegations about the record being barren and lacking, I wanted to make sure the court had access to the entirety of it. I think I was a little bit too cavalier in applying the entirety of the record, but because of the allegations that the record was barren, I thought we needed the entire record to make sure that that's not accurate, which I believe is not the case in the situation. I believe that the transcripts show a very different scenario than what Mr. Perez is arguing, that there were plenty of facts regarding the foundation from Mr. Officer Champion and from Mr. Caton.
So does that conclude your arguments, Mr. Brown?
Yes, Chief Justice, it does.
Yeah, and thank you for your explanations in reference to the procedural matters raised by Justice Torres and being forthright, and I appreciate that. So Mr. Perez, you have 2 minutes and 12 seconds remaining on your time that you reserved. Please go ahead and proceed.
Your Honors, I don't have anything further to say other than I think that as practitioners, we will benefit from the guidance that you're able to give us in your decision.
All right. Thank you, Mr. Perez, and thank you, counsels, for your arguments today. The court will take the case under advisement, and we will now stand adjourned. Have a good
Thank you,
day,
Your Honor.
counsel.
Thank you, counsel.
Thank you, councils.